Hello, everybody, and welcome to History Bite number 101, dated November 2nd, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The United States District Courts. The U.S. District Courts are the trial courts of the U.S. federal government. The district courts are where most federal litigation begins its life. That said, the district courts possess both original and appellate jurisdiction. Most of the district court's jurisdiction is original, meaning that is where you originate a case. Only a small percentage of its jurisdiction is appellate, and that primarily comes from appeals from the U.S. bankruptcy courts and certain other federal administrative agencies under limited conditions. The U.S. district courts possess the standard subject matter federal jurisdiction, that encompasses federal question jurisdiction, diversity jurisdiction, and supplemental jurisdiction, Of course, we recall from History Bite number 100, federal question jurisdiction involves questions arising under the U.S. Constitution, federal laws and treaties, and other types of questions arising under U.S. law in general, Diversity jurisdiction involves legal disputes between individuals living in different states, And supplemental jurisdiction allows the district court to decide matters that are connected to an existing case, though the matter would typically be decided under state law because it is connected essentially to another case that is pending before the court. The district court can decide the matter as well, So again, for further explanation on those types of subject matter jurisdiction, federal question, diversity, and supplemental, please refer to History Bite number 100, There are 94 judicial districts in the United States. Each of them is a separate district court, There is at least one U.S. District Court in every U.S. state and territory, with the sole exception of American Samoa, Some states, such as Texas and California and New York, have several, For example, the U.S. District Court for the Northern District of Texas, for the Western District of Texas, For the Southern District of Texas, for the Eastern District of Texas, so forth and so on. That's several. Other states only have one, like the U.S. District Court for the District of Maryland, and the U.S. District Court for the District of Massachusetts, States with just one district court location, The number of judges in each judicial district will vary based on the workload in that district, Quite simply, each U.S. District Court has a U.S. Bankruptcy Court attached to it, It's essentially an ancillary court, of which the District Court oversees and can decide bankruptcy cases itself under certain circumstances, which is why I mentioned earlier that the U.S. District Court can hear bankruptcy cases on appeal, But it also can hear them under its original jurisdiction powers as well, Now, with respect to district court judges, these are Article 3 federal judges that are appointed by the President of the United States and must be confirmed by the U.S. Senate, and they go on to serve during good behavior, or essentially for life, until they retire, resign, pass away, or are promoted to a higher court, which often happens as well, And last but not least, of course, impeachment and removal from office, but that's typically not likely to occur. It doesn't happen very often in the federal judiciary, So district court judges are supported in their role by U.S. magistrate judges who are appointed by the district court itself, as well as a very large staff of clerks, law clerks, and other support staff that work for the court itself, okay? In a district court trial, all right, it is presided over typically by one judge, though under certain circumstances, such as in cases involving the constitutionality of congressional district apportionment or those involving state legislative apportionment, three-judge district court panel may be convened. All right, but that's rare. Most district court cases are heard by a single judge, okay? And a jury may also be present, okay, depending on the type of case that is being heard, all right, or controversy mount in question, all right? So, with that in mind, to practice law before any U.S. district court, you typically are required to belong to its bar. Each and every single U.S. district court in the United States has its own separate bar, okay? And you are not authorized to practice law before it, okay, unless admitted, okay? Now, like most courts, the U.S. district courts throughout the country typically will allow pro hoc vice representation with the approval of the court itself, all right? And you typically also have to be sponsored by an attorney who is already licensed to practice before that particular U.S. district court. Each and every single U.S. district court has its own requirements for admission to its bar, but nearly, overwhelmingly, about 60 to 65% of them require that at the bare minimum you be a member of the state bar in which that district court sits. Okay, so for example, here in Maryland, okay, to practice law before the U.S. District Court for the District of Maryland, all right, one requirement for admission to the bar is admission to the Maryland State Bar. Okay, that's a good example, okay. Certain district courts have stricter requirements for admission to their bar, okay. It's entirely up to the district court itself, okay. Now for some facts. Now, the largest judicial districts in terms of judges are the U.S. District Court for the Southern District of New York and the U.S. District Court for the Central District of California, the two largest in the country, which each have 28 judges. That's a lot of judges for a single district. And the smallest ones are the U.S. District Court for the District of Guam and the U.S. District Court for the District of the Northern Mariana Islands, both in the Pacific, all right? Very sparsely populated territories. Each of them only has one district court judge, okay? Because most federal litigation begins in the U.S. district courts, these judicial bodies are the workhorses of the federal judiciary, okay? This is where a tremendous amount of federal litigation begins, as I mentioned earlier, and also ends, okay? District courts on the federal level, okay, just like trial courts on the state level, all right, are where a substantial amount of cases are both born and die, okay? However, that is not the case for all of them. Cases can be appealed from the U.S. district courts to the U.S. Court of Appeals, okay, which covers the state in which that district court is located, okay? So a case decided in the U.S. District Court for the District of Maryland could be appealed to the United States Court of Appeals for the Fourth Circuit, okay, which covers Maryland, Virginia, West Virginia, North, and South Carolina, all right? And under certain conditions, very, very rare and very rarely exercised conditions, cases can be appealed from the U.S. district courts to the U.S. Supreme Court. But I would imagine that such cases would have to present significant constitutional questions so urgently in need of adjudication that it is it is necessary to bypass U.S. Court of Appeals and go straight to the Supreme Court. All right. So, all right, that's an overview of the U.S. District Courts. All right. And each U.S. District Court, I'll add, by the way, also has a chief judge for its particular district. All right. So if you have any questions, controversies, please leave them down below. I appreciate you for listening to this History Bite and hope you learned something from it. If you have not subscribed to my YouTube channel, I humbly ask that you do so. It would be greatly appreciated. All of your support is very, 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 very appreciated. Okay? Thanks again for listening. Take care. Stay safe out there. And I'll talk to you at the next one. Peace. As always.